side will have 15 minutes, and that means the appellees are all experienced here, so I'm sure you understand, but I just would like to make sure that you know you're not going to get 15 minutes apiece.
We do, we have that arrangement, thank you.
Okay, thank you, thank you.
Thank you, Your Honor.
Would you like to reserve some time?
Yes, Your Honor, please. I'd like to reserve 2 minutes for rebuttal.
That would be fine.
Thank you. So, good morning, Your Honors. May it please the court, my name is Jeffrey Levinson. Along with my co-counsel, Mr. Hart, we represent the appellant, Robert Cohen, the receiver appointed here by Judge Hunter below for the estate of PEI Liquidation, Inc., which is formerly known as Patio Enclosures. Mr. Cohen serves as an arm of the court and a fiduciary for the interest of creditors, shareholders, and other stakeholders with respect to that estate. This is an appeal from the decision of the trial court, in this case granting summary judgments in favor of the defendant appellee board members. This court reviews that decision de novo, applying the same standard as the trial court. As stated in our papers, we submit that the trial court erred under Civil Rule 56 by finding that there was no genuine issue of material fact, and after reviewing the evidence most strongly in favor of the receiver, concluding that the board members were entitled to judgment as a matter of law on the grounds that the receiver's claims for breach of fiduciary duty are subject to the 4-year statute of limitations set forth in revised code 2305.09 and are not subject to the discovery rule, and that the remainder of the receiver's claims are not cognizable causes of action under Ohio law. As the several briefs filed in this appeal make clear, there are myriad factual disputes among the parties in this case, ranging from the cause of PEI's demise and the resulting damages to the company's creditors and stakeholders, to the responsibility of the board members for those damages. This court respectfully need not act as the trier of fact as to those disputes, because the essential issue before this court is whether the trial court erred by granting summary judgment in the board members' favor under Civil Rule 56C on the ostensible grounds that the complaint fails to state a claim for fraud with the particularity required by Civil Rule 9B, and that the claims therein are therefore not subject to the discovery rule. We respectfully submit that a proper review of the complaint clearly demonstrates that the receiver has stated the circumstances constituting fraud with sufficient particularity in accordance with the requirements of Civil Rule 9B. In reaching its result to the contrary, and after conducting what it terms a thorough review of the complaint, making reference to only selected paragraphs thereof, the trial court summarily finds that the receiver has failed to state a fraud claim with the particularity required by Civil Rule 9B, and thus holds the receiver's claims to be time-barred by the statute of limitations. We submit that the trial court erred in this respect. As the court is aware, Civil Rule 9 contains certain exceptions to the general rules of notice pleading contained in Civil Rule 8. One such exception is the requirement contained in subsection Civil Rule 9B, which states that, quote, in all averments of fraud, the circumstances constituting fraud shall be stated with particularity. Courts, including this one, in the F.J. Roofing case cited in our brief, generally construe the phrase, quote, circumstances constituting fraud to mean the pleader must state the time, place, and content of the false representation, the fact misrepresented, and what was obtained or given as a consequence of the fraud. Here, there's no doubt that the receiver states the circumstances constituting fraud with such particularity. Taken together, the whole of the 105-paragraph, 32-page complaint with its multiple charts and graphs tells in exacting detail how it was that certain of these appellees, despite knowing the precarious financial condition of PEI, approved a transaction which stripped the company of needed cash, left it insolvent, to the manifest injury and damage of the company's creditors and employee owners, and how the later serving directors did nothing about it. Thus, the complaint contains ample detail with respect to the circumstances constituting fraud, and the actions and the inactions of board members, and the consequences thereof which give rise to the receiver's claim for breach of fiduciary duty for fraud, the requisite particularity of the time, place, content of the false representation, the facts misrepresented, and what was obtained or given as a consequence of the fraud, all of which is detailed from the very beginning of the pleading. In paragraph 1, the complaint states the context for these claims. It states that the lawsuit arose out of the collapse of PEI in 2010, and that in violation of their fiduciary duties to PEI under corporate law, certain of the appellees approved a stock purchase transaction in 2006 that ignored the clear working capital needs of the company and left it inadequately capitalized. In addition, certain of the appellees failed to act on a proposed loan guarantee in 2009 that would have prevented the collapse of PEI and the resulting unpaid claims against the estate. And finally, as PEI underwent its inevitable failure, all appellees persisted in their failure to take subsequent corrective action with respect to these facts. Paragraph 2 summarizes the receiver's investigation and analysis of the financials leading up to the company's collapse, the losses year after year after year. Paragraph 3 reports that a possible saving grace came in 2006 when the company got $10 million from a judgment. Paragraph 4 states that these defendants knew the consequences of these actions. And paragraph 5 states critically that these facts were hidden by all defendants from parties doing business with PEI. It was not until after the appointment of the receiver that any independent review of the board's actions was conducted. That review discovered that as a direct and proximate result of these defendants' acts and omissions, PEI suffered no less than $10 million in damages. The 100 paragraphs of the complaint which follow provide the details. Furthermore, the complaint is sufficiently particular to satisfy the purposes of Civil Rule 9b, inasmuch as the board members were informed of the acts of which the receiver complains, and the board members were thus enabled to prepare an effective response and defense in accordance with the decisional authority of this court. This court has specifically held that Civil Rule 9b requires that the pleadings must be sufficiently particular to apprise the opposing party of the claim against them. That's the F&J Roofing Company case, again cited in our paper. This court has further held that the Civil Rule 9 requirement of particularity must be applied in conjunction with the general directive in Civil Rule 8 that the pleading shall contain, quote, a short and plain statement of the claim, close quote, and that each averment should be, quote, simple, concise, and direct. That's F&J Roofing, 35 Ohio App. 17. The court there cites several decisions, including Moore's federal practice and a decision from a federal court style Commonwealth Oil Tesoro Petroleum Corporation securities litigation, which is actually worth quoting at length. Courts have not struck a balance between these rules, that being Rule 8 and Rule 9, by devising an easily applied test. Indeed, despite the many applications of Rule 9b, no standard has evolved dictating precisely how much notice the rules require. No court has enunciated a test which casts light beyond the facts before it. This is not surprising. The nature of each individual case will necessarily determine the degree of specificity under which Rule 9b is appropriate. And here's the critical part. The focal point of a Rule 9b inquiry should be whether, given the nature and facts of the case and the circumstances of the parties, the pleading in question is sufficiently particular to satisfy the purposes of Rule 9b. The rule has three purposes. First, it ensures that the allegations are specific enough to inform the defendant of the act of which the plaintiff complains and to enable him to prepare an effective response and defense. Second, it eliminates those complaints filed as a pretext for discovery of unknown wrongs. And third, it seeks to protect defendants from unfounded charges of wrongdoing which injure their reputations and goodwill. Thus, critical for present purposes is the fact that the board members were indisputably on notice for the filing of the complaint of the acts and omissions that formed the basis of the receiver's fraud claims against them, and that they were thus unable to prepare an effective defense. Indeed, the trial court here found precisely that in initially denying the board's members' dismissal motions, which were filed at the very start of the case, and then denying again their reconsideration motions. The decision of this court in F&J Roofing instructs that is all that was required of the complaint under 9B, and that was precisely what the receiver did in the complaint. Moreover, when faced with the summary judgment motions under Civil Rule 56, the trial court was to look beyond the complaint and to the evidence, and only the evidence, presented by the receiver in support of his claims. That's Civil Rule 56C. As noted in our papers, the receiver submitted ample evidence in opposition to the summary judgment motions, which would have also rendered summary judgment improper under Civil Rule 56C had the trial court proceeded correctly. Among other things, the receiver demonstrated as a matter of fact that PEI began experiencing significant financial deterioration no later than 1999, that it was clear well before the 2006 transaction that the company would continue incurring net operating losses, that the board members nonetheless elected to approve the 2006 transaction, therefore transferred $10 million for the benefit of its controlling shareholder, leaving the company woefully undercapitalized as a result. That the board members knew of the company's deteriorating financial condition, that the board members hid these facts from parties doing business with the company, continuing operations, notwithstanding its insolvency, and incurring significant additional debt as a consequence, and therefore knowingly failed, and thereafter knowingly failed to take subsequent remedial action with respect to the 2006 transaction, including by instituting suit at a time when the claims here were not at risk on account of the statute of limitations. Construing this evidence most strongly in favor of the receiver, as Rule 56C requires, quite clearly does not make it appear that reasonable minds can come to one conclusion, and that conclusion is adverse to the receiver. The need to hold in the face of these facts that summary judgment in favor of the board members was appropriate under Rule 56C because the complaint allegedly failed to state a claim for fraud under Civil Rule 9 was clear error by the trial court, and the decision should thus be reversed. The trial court based its decision entirely on the four corners of the complaint, but offered no explanation of its decision as to why, applying the same standard to the exact same document, that same court reached the opposite conclusion as to the earlier dismissal motions.
Counsel, you're in your 2-minute rebuttal.
Thank you. And the consideration of motions. I will reserve the balance of my time. Thank you.
Good morning. My name is Ron Cott, and it please the court. I represent what are referred to in this case as some defendants. I'm trying to remember why we came up with these different designations, but we did. And so I represent in this court today Thomas Dulay, Thomas Edgar, Ken Seckley, Craig Cox, Jeff Roars, and Kevin Dow. We have agreed between counsel that I will speak for 7 minutes, and each of the other 2 lead counsel will speak for 4 minutes. So I will sit down in 7 minutes. Your Honors, this case arises out of patio enclosure's use of proceeds that were obtained by it as a result of a case that I and my partner, Red Bernard, tried back in 2004, resulting in an approximately $10 million judgment in its favor. And that judgment was affirmed by this court in 2005. The Board of Directors, as you have read, determined that it would go forward with what it decided to do almost 10 years previously, which was to complete the ESOP purchase, the employee-owned purchase of the company, which it did in 2006. But it not only did that, but in the process paid off all of the company's debt. So that in 2006, prior to what we know as the Great Recession, This company was completely employee-owned, and it was completely debt-free, and it had raised its revenues in each of the preceding 10 years. It was a very, very healthy company. Our clients have been criticized in this case essentially for not predicting what became the Great Recession. They've been sued for supposed wrongs which have never been recognized under Ohio law. I believe that our brief adequately addresses those, and so I'm not going to address them here. What I do want to address briefly is what the receiver in this court and in his argument seems to be stressing, and that is the statute of limitations related to fraud and the pleading of fraud with particularity. No one disputes but that the statute of limitations for breach of fiduciary duty is 4 years, and it is 4 years from the date of the wrong. That's section 2305.09. The dispute concerns whether or not the breach of fiduciary duty here was based upon a, quote, fraud, and whether or not that was sufficiently pled or proven. We would submit that in this court's de novo review, it would be very easy for you, if you have any concern, to look at the very ample evidence that demonstrates that there was absolutely no fraud. The receiver argues that breach of fiduciary duty claims are based upon fraud, and therefore that the discovery rule should apply, that there was no accrual until he discovered, that is, the receiver discovered the fraud sometime after he was appointed as receiver in 2011. Now, mind you, he was appointed in 2011 and didn't file this lawsuit until 2014, but nonetheless, I would just ask you to consider what any opposite ruling from the ruling of this court would do to public policy. That is, we would go back years and years, we would go back to the Great Depression, really, if a statute of limitations as to some breach of fiduciary duty ostensibly based upon fraud was not to begin tolling until after the receiver is appointed. That receiver, I guess, could go back decades, and that would be highly against public policy, we would submit. So it's important to look at what we were dealing with, we as the lawyers in this case and the parties when we were served with this complaint. And what we were served with was no amount of idle chatter. It is a 36-page long complaint with, as indicated, over 100 paragraphs. And so when we get to fraud, or actually what is the breach of fiduciary duty, I would please direct your honors to paragraph 73 of the complaint on page 26, which goes through specifically what these folks claim is a breach of fiduciary duty. And there are 5 subsections. I won't go through them specifically, but things like, as to all of my clients, that they approved this stock transaction in 2006. No pleading of fraud. As to defendants Dulay, Edger, Schneider, and Seckley failing to act on a proposed loan guarantee in 2009. No allegation of fraud. If you go through each of the 5 subsections of what they claim to be a breach of fiduciary duty, there is absolutely no allegation of fraud. There's not the use of the word fraud. There is not the heading of fraud in any of the subsections on causes of action. There is no mention of fraud whatsoever in this complaint, except in 2 or 3 paragraphs, such as paragraph 74, and they were each identical. Paragraph 74, after going through these allegations of breach of fiduciary duty, all they say about fraud is each of the defendant's acts or omissions described herein was alternatively either fraudulent, willful, deliberate, knowing, in bad faith, reckless, grossly negligent, or negligent and in derogation of Ohio law. That is their only pleading of fraud with quote-unquote particularity. And we would submit also, and the record will reflect this in the file that the court has, when we asked in interrogatories, what are you claiming as being breach of fiduciary duty or fraud, their answer was specifically, refer to the complaint, it's all there. And that's all we got out of this, and so that's what we are dealing with. The other part of fraud that one has to plead with particularity would be who was defrauded and who justifiably relied upon that fraud. So we think that there are major problems here. There simply was no tolling.
Counsel.
Oh, I'm sorry.
That's okay, I was talking very loud. Yet, counsel of court reviewed that complaint on a motion to dismiss, and it's so obvious, you're saying, but the court just missed it the first time?
Well, I will tell you, we thought it was so obvious that we asked her to review it.
And then
And
still
she
denied.
she still did not. She wanted to give these folks, we would contend, the chance to get through and do their discovery. We did, I don't know, dozens at least.
They did it on the same basis?
Right,
It
and
didn't
so.
do it on the basis of, genuine issues of fact on that particular issue, but just on the basis that it wasn't pleaded with particularity.
Right.
Which I understand is interlocutory, she has the right to do that, or the trial court has the right to do that, but it's very unusual.
It is unusual, and we would submit, and I certainly felt that the judge was very mistaken in overruling the original motion to dismiss and allowed this case to go on for a very long time, and it should not have. That alone should not be a reason for reversal of this case simply because she made a mistake, we believe, in ruling on the motion to dismiss. Thank you.
And I digress, thank you.
Good morning, Your Honors. My name is Orville Reed, and I represent Robert Schneider in this action. Your Honors, I along with Mr. Kopp, also filed a 12C motion, and also asked for opportunity for reconsideration. And I also agree with Ron that we think the court made a mistake at that time. I guess it's understandable. Rule 12 motions are not generally welcomed by the court. There's been no discovery. It's at the outset. Maybe there'll be amendments. Perhaps there'll be evidence that comes along to support things. So I would assume that the court was giving the plaintiffs the opportunity at that time, where the burden is on us in a 12C motion, to prove that there's no way you can state a cause of action here. The court gave them that chance, overruled our motions, and we proceeded. And then it comes time for Rule 56. And then the burden passes to the party against two of the motions made to prove there's a genuine issue of fact. And I would point out to the court, as we didn't know...
After the original motion for summary judgment, after the initial burden was met.
After initial burden is met, correct, Your Honor.
So it still was your burden at that point.
It was, Your Honor, to prove there is no genuine
Right.
issue of fact, and we're entitled to judgment as a matter of law, correct, Your Honor. I would point to the court just the manner in which the plaintiffs named their causes of action. And I do that on page 19 of my brief. Count 1, how do they describe it? Breaches of fiduciary duty and law. Right. Now, I think we can all agree that not every breach of fiduciary duty is fraudulent. That's just a fact. Not every breach of fiduciary duty is fraud, and you don't have to prove fraud to establish a breach of fiduciary duty. And so what do they do in count 1? They call it breach of fiduciary duty and law. What do they say count 2 is all about? They call it aiding, abetting, or participating in fiduciary duties and other misconduct. There is no reference to fraud. How do they describe their cause of action in count 3? They call it waste. And how do they call count 4? They call it deepening insolvency and wrongful prolongation of corporate existence. And 5 is breaches of fiduciary duties owed to creditors. Nowhere in the caption of this complaint, anywhere, and this is their work, this is their handiwork, do they say there's a fraud cause of action. The other thing that I mention is the fact that probably the seminal case for what has to be alleged, at least, in a fraud case is found in Crosby versus Beam at 83 OAP theory, that this court refers to all the time, cites often, and cited by other people in many cases. And Crosby versus Beam says you've got to prove a misrepresentation of fact, you have to prove that, you have to allege that it was fraudulent, it was made with the intention to fraud. Thirdly, that somebody justifiably relied upon that. Fourthly, there was reasonable reliance, and then there's damages as a result thereof. Okay, we have, in this case, 2 transactions that are the subject of this 100-some count complaint, 100-some allegation complaint. And that is a 2006 transaction pursuant to the terms of which they completed the ESOP transaction that began 10 years before that in 1996. There was nothing hidden about that. So even if you had a discovery rule, there was nothing hidden about that transaction. It wasn't hidden. It wasn't done under the cloak of darkness or secrecy. Somebody put a cloak around this. It was a fact that happened at a board meeting. The ESOP was completed, and the monies that were earned as a result of Mr. Kopp's efforts in an action brought on behalf of PIE were paid out. And as a matter of fact, this is not $10 million we're talking about, because most of the award that Ron got in that case were punitive damages. They would have been subject to income tax, except for the fact that this transaction allowed all of that money to be used on a non-taxable basis. It was an astute decision by the board to complete this transaction at that time. The other transaction they complain about is the fact that in 2009, when Mr. Schneider was no longer a board member, no longer had any fiduciary duties, was not a CEO any longer. He had resigned all those positions in 2006 and 2007, and the claim is that there was a breach of fiduciary duty at that time. What was hidden? Nothing was hidden. As a matter of fact, in 2010, the evidence is that Mary Pilla came on the board. Mary Pilla was a lawyer, a litigation specialist with Nestle. She came on that board. She examined this transaction and determined not only was there no merit to bringing a lawsuit against anyone arising out of this, but it had so much to recommend it was exactly the right thing to do. Finally, one other thing, and that is the plaintiff in this case was cross-examined. The plaintiff was cross-examined, and he was asked, and I've cited this specifically in my brief, the plaintiff was asked, Mr. Cohen, tell us, what is the fraud in this case? You claim there's fraud. You used the adverb fraudulently a number of times, as Mr. Kopp pointed out. You use the adverb, well, what is the fraud? The fraud, according to the plaintiff, the receiver, the man in charge of this corporate estate, says the fraud was the fact that the projections made to Stern Brothers, and that was the advisory firm that was casting its gaze over this entire ESOP transaction, that the fraud was they overprojected their income. They overprojected that was the fraud. So, Mr. Sickerman, who was doing the cross-examination, said, I'm just about out of time, Your Honor.
Yes, you are, that's what I was going to.
I'll wrap it up. Thank you, Your Honor.
Is there somebody else arguing?
Yes, can I finish this?
Only 35 seconds.
And the other thing, he was asked, well, who relied on that? And his answer was, I don't know. And so the question was asked, it was entirely speculative whether anyone relied upon these overprojections, alleged overprojections of income made not to creditors, but rather to Stern Brothers. And he said, it is speculative. It is totally speculative. There is no fraud here. It's not alleged, and it certainly wasn't in the evidence. And I would respectfully request this court to affirm the judgment of the lower court. Thank you very much.
May it please the court and respected counsel, I'm Dan Ballmer, and I have the privilege of representing the later defendants, Frederick Reams, Robert Zelensky, and Ms. Mary Lee Pilla, who is present in the courtroom today. I refer to them as the later defendants, Your Honors, because it is uncontroverted.
And you better just get to your argument, because you're actually out of time. I'm just affording you some time as a courtesy.
I appreciate it, Your Honor. Thank you. Mr. Kopp is right, never go last. What I would ask the court to consider would be not only the statute of limitations, arguments which apply to my clients as well as to all of the defendants, but also to acknowledge that these defendants, the later defendants, came to the board after the 2006 decision, after the 2009 decision. It is uncontroverted. They were not present, did not vote, did not facilitate, did not negotiate, had nothing to do with the two transactions, the two board actions that are complained of by the plaintiff. They came after the fact. And the law does not support a claim against them. If indeed there is some duty to investigate and to bring suits, and there isn't, it is a novel claim. It's a theory that grows out of the fatal consequences of the statute of limitations and the fact that my clients neither voted on nor influenced the two decisions that are complained of. But if there is such a duty, then everyone in this room, before we ever accept an appointment or an election to any board, whether it's a board, a nonprofit board, or a for-profit board, we better be prepared to engage and retain a battalion of lawyers and accountants and financial specialists to examine every decision of that board before we go on it, or we will be faced with the type of lawsuit my clients are being forced to defend. They came to the party late. They have no business, and this court should affirm the decision.
Thank you.
Thank you.
I'm going to give you an extra 145.
Thank you. Thank you. Two things. First, to pick up Mr. Palmer's point. These later directors did not come into a healthy corporation. This company was troubled. They knew about a significant asset that had gone out, and yet they did nothing about it. The statute of limitations might still have been available to them, might not have applied, and yet, as we said, they did nothing. Most importantly, though, let me quote from Judge Jones's order on the motions to dismiss at the last page of the order. She states, construing the complaint most favorably to plaintiff as she was required to do there and here. The appointment of the receiver in 2011 and the allegations of fraud as set forth in the complaint are sufficient for this court to deny the defendant's motion to dismiss on the defense that the statute of limitations has run. This court is right. She ruled that way once. She ruled that way twice. And then the third time, inexplicably, without even referencing these earlier decisions, she rules another way. Now, the standard here is, can reasonable minds come to but one conclusion? Clearly, this court came to three conclusions. Two of those conclusions were that the complaint adequately alleged fraud. A motion to dismiss was denied. She applied that same standard to the same document and came up with that conclusion again on the motion for reconsideration. Only when faced with a motion for summary judgment, ignoring all the evidence, did she suddenly come to a different conclusion. Certainly, this judge is reasonable. Obviously, the court came to two different conclusions. Counsel argued facts in their presentation. That's not this court's province, necessarily. In terms of the fraud, they misrepresented solvency. They knew it. Creditors relied on it. They were left holding the bag when this company failed. Their damages are the millions of dollars in unpaid claims. The fact that this company had experienced losses for a long, long time makes this tax argument completely illusory. They alone knew the financial condition of this company. Creditors relied on the implied representation of solvency. When you buy something on credit, creditors think you can pay it. Otherwise, you wouldn't do it. That's the reason why there's laws about this. That was not the case here. They allowed this company to continue operating, running up millions of dollars in debt when it couldn't pay for it. The fact they alleged that all the debt was paid is not accurate. They refer to the gross revenue of the company as increasing. The problem was that the net revenue was decreasing. This company was losing money hand over fist. It took a long time to wade through all of this. So the fact that the receiver was appointed in 2011 and we've got a defunct company with a bunch of files in a warehouse someplace, he's not going to be able to figure this out quickly. We did significant investigation. It was only after that investigation that we prepared a 100-paragraph long complaint. This isn't something that we just slapped together. This is real. As they said, a breach of fiduciary can be breach of fiduciary duty can be based on fraud, and here it was. And the complaint uses the term fraud throughout. It's the label applied to what happened. What's contained in the complaint are the facts.
Counsel, you're up.
We would ask that the court,
There's just one question.
I'm sorry,
He did say that all the debt was paid off, and then you just said that it wasn't.
correct.
Did he say that all the debt was paid off back in 2006, I think when the $10 million judgment came? Was all debt paid off at that time?
If you look at the record, you'll see that there were outstanding accounts payable at the time. That the company has, this is somewhat of a cyclical business, so it's not the case that, you know, if it's left with no money, as this company was, that it's adequately capitalized going forward. It has to buy the material, it has to pay the labor to do the work necessary to manufacture the product that it did. It didn't have sufficient funds. It ran up a bunch more debt. That's what happened.
Thank you.
So again, we would ask that the court reverse the decision below and remand this case for trial. Thank you.
Thank you. Thank you both sides, to both sides, I should say. And the court will take the matter under advisement. A written opinion will be prepared and sent to both sides, as well as you can look on our website where we release it electronically. Thank you.
Thank you.